What's up, guys? Listen, I'm doing a quick test. I want to see if you guys can actually hear the audio. We are going to be covering this live stream, but I need to make sure that you guys can hear the audio. I wanted to do a quick recap.
We went back through all the reports to make sure that he had everything he did.
Pat,
It turns out
please
that in
um
January,
say something if you can hear the audio.
January
All right, let's
2024,
get into this.
there was a comparison done, and I want to be clear what we're talking about. There were two expended cases that
Let's
were
see.
found at the crime scene by the victim in the case.
What was the date?
Okay, so what we're at here, let me just pause this really
What was
quick.
the date that the
Listen, we're doing a recap for those of you guys that joined the ASAP live stream. They are currently on a court recess. It's going to be 3 hours. But what happened even before opening arguments, I think, was the most amazing thing in the fact that the judge is literally messing with the prosecutor. Well, not messing, but challenging the prosecutors to show that their whole theory holds weight and that the shell casings, which were not found by the police, but were found by ASAP Relly, that the shell casings should actually be admitted as some type of evidence to the point that they prove anything besides random shell cases were found not by the police, but by the alleged victim himself. Okay, so listen, I'm going to play the video and then you guys let me know if you can hear this. We are recapping while they are on recess for, I think, the next few hours. We are going to recap. Hold on.
suspended casings were turned into the police?
The
Can you
day
guys
of
hear
the
the judge?
It would
Yes
have
or
been
no?
2 days later when you reported it to the police.
In other words, back at the time.
And Sugar,
this happened,
Shayla, can you guys let me know
All
if you
right,
can
so the
actually
incident
hear it?
occurred on November
Here.
6th, so it would have been around November 8th?
Yes.
All right.
So that he turns them in,
Can anybody hear?
there's work done on the casing, unbeknownst to co-counsel, myself, I
Let's
was
check.
on the case. They ended up doing a further examination of the casing. That examination revealed.
Hey, what's up, guys?
that in
We're back.
fact,
Misery, can you guys hear?
are
Mystery, can you guys
consistent
hear?
with having been fired for 9
Okay, you guys can hear. Okay.
from certain 9mm handguns. There are some markings on the casings that are somewhat unique, and they can basically track them down to a much smaller.
So again, really quick, the judge is challenging, saying, listen, these shell casings were not found in police custody. They weren't found in investigation. The alleged victim found them. Why should we use this? Because these shell casings look like they can come from anything. The prosecution is now making the argument, Your Honor, these shell casings have special markings on them, and we can actually see that it came from the alleged firearm that ASAP Rocky was using. Okay, we're on the same page. Let's go.
Smaller subset of firearms that could have caused the marks on the casings. Included in that is Glock 43. So,
Hold on.
okay,
Did the report say that the casings could only have been fired from a Glock 43, or could a Glock 43 be among the type of firearms that the expended casings could have come from?
let me read the exact conclusion. Items 1A and 1B.
Those are the
Those
casings.
are the casings. Each exhibits characteristics typical of aftermarket slides or a series of subcompact pistol frames, including but not limited to polymer model PF9SS, Glock store model SS.
Wait, slow down because the court reporter needs to take these.
Sure. Polymer 80.
Now, the prosecution still won't admit that it's an exact match.
Glock store model SS80 and Glock model 43 and 43X. We have been given information that in fact, oftentimes and frequently when you're looking at casings, you're not able to get a whole lot of information. But it turns out that the markings on these casings are a bit more unique, and they are not only consistent, but the examiner will testify that the markings he has seen very rarely, and that where he has seen them, where they've been recorded, are with a Glock 43 pistol.
What's the
Now, this is very interesting because the prosecutor is going around in circles. The judge is like, are they an exact match to the alleged firearm? They are saying that they'll have an expert testify that those markings are consistent from a firearm that ASAP Rocky is being accused of, but they cannot say it was the exact firearm. This is a big get for defense. It doesn't seem like the judge is falling for this either. And it doesn't escape the court's attention that what is the point of having a firearm, right? What is the point of having a firearm expert come and say, yeah, these bullets could have came out of this type of bang bang? Because we're trying to see if that's the case, ASAP Raleigh could have gone around the corner and been like, and then picked up the shell casings, like many people think he did, and then go to the police and say, look, please, look what I found. It's like at this point, you're basically saying that evidence can be falsified.
What's the name of the examiner who did this ballistic comparison? Or
The
ballistic
examiner's
examination?
first name is going to be Fidal, last name
Rocky, you got fresh straight backs.
D-I-R-A.
IMAH.
Mm-hmm.
So the way this came about was we were looking at a different issue. The detectives yesterday afternoon sent an email to my co-counsel basically saying, hey, take a look at that report, this report that we're talking about.
Which detective?
In the attachment.
Detective Flores.
Flores?
Flores.
From Every Homicide?
Yes.
Go ahead.
So when this was received, my co-counsel looks and says, I've never seen this report. So he goes back in discovery, looks at emails, we don't have a report. So we instantly contact the defense, send them out the report. I want to be clear, the report is inculpatory, not exculpatory. So obviously, not only do we have no motivation to have not turned over this report, RHD has no motivation either. What's very clear is that they believe they had turned it over, and they did it.
What time did Detective Flores bring this to either your attention or Mr. Frizoni's?
Yesterday afternoon, you want the exact time?
Approximately.
It was yesterday afternoon. We were in court. We went back to the office after court yesterday, and that's where we went back and looked to see, do we have this discovery?
So something after 4:30 p.m.?
The email is timestamped 3/18, but I got it when we, so it was essentially received but not gone through yet until I could get back over to my desk.
You conveyed this to the defense when?
Okay, if you're wondering why they seem so petty and why they're arguing over this, it's because they are trying to say, both sides to a certain point, that evidence is coming in with not enough time for them to review it. If they can convince the judge, oh my God, they just sprung this on me. What am I going to say? If they can convince the judge of this, then this will be huge for, if they can convince the judge of this will be huge for their actual case, because that means either side can get evidence excluded. The more evidence that is excluded, the better their cases will be. Because at the end of the day, that's always, since they do not actually have a video clearly showing ASAP going bop, 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 and rarely getting hit, and shell casings, this is all going to be coincidence. This is all going to be circumstantial evidence. So they are literally trying to get as much evidence excluded as possible, because that's the way this case actually will be won. But let's keep going, okay? So the prosecution now is like, well, we got notice after 4:30. That's not really a lot of time. And the judge is like,
We sent it to them at 5:21.
So about 40 minutes later, they're
Yes.
done?
Because the first thing we had to do was, we had to go back and see, have we already turned this over? So we not only emailed it, we called them. We explained the situation. The response at the time that we gave it to them initially was, well, this is the same thing that you have accused us with respect to the witness and the court's finding that they violated the court's discovery order. And we responded, no, this is completely different. You had interviews starting last August.
I don't want to get into who said what. I just want to know the sequence of events.
So at this point in time, we had a discussion. We sent an email at that point to council, and we included the court. There was an email sent late last night.
Now pause. I know this might seem boring to you guys, but this is very funny. So this is ASAP Rocky's lawyer is now trying to explain why they gave evidence last minute. And you can tell this man's mind, he's a very good lawyer. You can tell his mind is twirling because the judge is like, but when did it happen? So when it happened was at a time period where let me get to the point. So he is trying to find a way to spin this information to ASAP's benefit.
At some point by Mr. Tacopina. I did not see it until somewhere around 2 in the morning. In that email, Mr. Tacopina cited the Hughes case. There were no facts in the Hughes case. I went in the middle of the night, I got the case, I read
I
it.
don't want to know about it. This would be appropriate if you want to argue your position.
Thank
I
you,
just
John.
wanted to know the sequence of events.
Right, I'm not gonna go any
Hurry
further,
up.
other than to tell the court. I read the case, I then sent an email at
The judge is saying, counselor, we have lunch. You're going to have to wrap this up in 20 minutes.
roughly 3 or 4 in the morning. I sent it to council, and I sent it to the court.
All right.
The last, can I have just one last factor on it,
Yes.
which is, I knew from past experience with firearm analysis that there would be a lab file or bench notes associated with the analysis. So I tried to immediately contact the lab to expedite and see if they could send that to me immediately, but they were not open at the time that I called. So we had to call
Really?
this morning at around 6, and they scanned it and sent it over, and I sent that to the defense as soon as I got it.
How many pages is this report?
The
It's
report
listed.
is one
The
page.
report itself is
It's
one page.
One page. How many pages are there total of all the police reports, all of the discovery in this case?
Now, the 6 a.m. thing, I think the judge should put his foot down a little bit more. It is unacceptable for them to have forensic ballistic specialists run by a lab. He was like, oh, we couldn't call. And the prosecution has said, but don't worry, we sent ASAP. This is evidence 6 a.m. in the morning. It is a sneak attack, but to be fair, all's fair in the court. Let's keep going.
How many pages?
Regarding this one,
Regarding the total number of,
regarding this one.
No, I was,
no,
Yeah,
the
I know.
total number of pages involving this
Yeah, I know.
case and this investigation.
I would estimate 100 or over 100 pages.
100 pages.
I mean, to be totally candid with the court, I haven't counted them, but that's just ballparking the various reports and things that we've received.
All right.
Okay.
I understand now the sequence of events. All right. Who wants to speak to the defense?
I think, I'll start. Maybe Mr. Siegel, if I leave something out, because we tackle this together. I mean, we spent literally the night before our opening, about 5 hours.
Okay.
trying to do it.
Speak slowly. The court reporter needs to get everything down, and I want everybody to know exactly what you have to say. Go ahead.
So,
Okay.
and I'll
Defense
just
is
stick
speaking.
with sort of the chronological order here. I'm not going to argue case law or anything like that, but aside from the fact that we lost 4 to 5 hours the night before our opening dealing with this, we this morning, after we get an expert report last night that was in the possession of the lead case detective in this case, not some random police officer. Detective Flores is the case detective in this case. I have to believe he understood the importance of that report.
Okay.
He testified at preliminary hearing. After we get that report that says, in conclusion, that the subcompact pistol frames, including but not limited to, which means absolutely nothing. So it could be a universe that we don't even understand of other pistols, and then goes on to list 3 of them here. This morning, we got another 28 pages of backup data on this. Backup lab, I guess, report that normally comes with a conclusion report. We got this morning. I find it hard to believe that the lead detective in this case didn't bring it to anyone's attention from the district attorney's office until after a jury was impaneled the night before opening statements. I mean, something that they now are saying is such a crucial piece of evidence. We have an issue now with the jury, obviously it's a jury panel. It may affect, quite frankly, whether we would have kept or not kept a few jurors, one in particular. Then we assured him yesterday he'd have a fair trial. You're gonna have a fair trial. We've made issues regarding the veneer, you know that, I'm not gonna rehash that. We're here, we're ready to open today. I don't even know how we're supposed to do this. This should be suppressed without question, because it changes the complexity of the case. We're not, at the very least, we have to quash this panel and start again, or strike jurors, reselect. I mean, I think even the district attorney said, okay, well, continuance is appropriate. We paid the jury. We're ready to go. This is something that, you know, to render fair and effective representation here, as we all assured Mr. Mayor we would have, in the midst of a trial that's already underway, we would need to locate and retain our own expert to conduct a scientific analysis. Their report was 28 pages. It took them, according to them, it took them 1 week to do this. 1 week. And that's their own lab, with their own on-staff experts. And it took them a week. How long is it going to take us? We have to go find somebody first, hope he's available, the trial will be over.
True. He makes a good point. The prosecution is, well, let me tell you, like, what's going on, at least in my opinion. The prosecution is very, very mad that ASAP Rocky made a very, very, very good sneak attack on them yesterday prior to the hearing, where they said, guess what? It wasn't a real gun. It was a stunt gun. Even though you guys think you got the gun, it was nothing but a prop. The prosecution is furious that they were allowed to get that one off. So the prosecution, oddly enough, had their own little ace in the hole. And they literally said, well, guess what? We did forensics on the bullets, and the bullets had to come from a gun. That was like the one we said you had. So now the judge was haggling like, wait, a gun or the gun, right? And the prosecution has been hemming and hawing, but not even that. These ballistics that they said they had evaluated by a lab and expert, they said they just got it in at 6 a.m. this morning. So, oh my God, Your Honor, we shared it with the defense, and the defense is like, pause. You told us that it would take a week. It took you a week just to get this report. This report is like 100 pages. It gave you a week. How are we supposed to get an expert in that can actually do anything in this time? Because this trial is only supposed to last for a week or two. So how are we even supposed to get an expert to test that your expert is telling the truth? This is why ASAP's defense is going crazy.
Casings, scientific testing, I mean, if you look at their report, I mean, they cite like some of the basis for their findings is the internet. They went on and cited all these websites and forums. I mean, there is so much work to be done here to even understand this conclusion. I mean,
All right, so what do you seek?
what am I seeking?
What are you asking for?
Your Honor, I'm asking, well, and our
Asking
letters.
for justice,
I don't
Your Honor.
want to rehash it, but our letters laid out pretty clearly what we're asking for. There's no way to proceed in this case if this is admitted. We have to either strike this whole panel. We need a continuance. We gotta
Okay,
start again.
you're not getting the whole panel strike. Stop.
What I'm asking for is you conclude this. This is after the jury was impaneled. This is a major piece of evidence that will require us to do a lot of expert work that took them, their own department, a week to do. That's the only thing I'm requesting. Short of that, Your Honor, I can't even open if this is coming in, because I have to deal with the address. I don't even understand it.
I don't even understand it, Your Honor.
28
What are
pages.
these words?
A back of data. So that's what I'm requesting. I'm requesting this to be concluded. It's after the jury's impaneled here. You know, as Seal just pointed out, there's also a balancing argument under 352.
So he's losing the judge right here.
which I think is also something that's relevant here, including not limited to, but, you know, we have this whole, I don't know what to say here, Your Honor. I really
What
don't.
is going on with
I want to
ASAP?
make
Is
sure he
he
gets a fair
even
trial.
he is disassociating
Here
like a
we're ready to
mug.
go. We all
They
sure
reaching
we
over
get
him,
a
he's
fair
not even
trial. And
blinking.
this is, I've never seen anything like this. I'm not gonna talk about the other witnesses, the late Brady disclosures, or the witness we got the name of for the first time last night. I'm not whining about that. I know that's what they want to keep doing. We both have had issues with that. That's fine. I'm
Okay.
not gonna make it an issue of it anymore. You've already ruled on that. Period, end of story. This is now a new one. You know, I don't want to get into, I told you so, but many people said to me this morning, I told you so, that this was gonna happen.
Well, then why did you have a plan
I-
B?
I'm trying to keep my composure, Your Honor. I don't know if I've ever been this upset.
Listen, the lawyer is losing the judge because spoiler alert, right? They're arguing over evidence related to the bullet casings. Now, ASAP, as you see, the lawyers are reaching over him. He is just sitting there looking like a dead, like just looking stoically forward. The reason he is doing that is because there's a lot on the line. If you guys heard in the chat, we're about to get into live stream again. We're doing a recap to break down all the legal things. If you guys notice, he's facing 24 years in jail. Some people said, why didn't he take the 180 days? I wouldn't have took the 180 days. The fact that they even offered this plea bargain lets you know that the prosecution's case is very weak. They have a video of sound of him allegedly going bang bang at someone. However, and it's important to note, he's saying it's a prop gun. Prop guns actually make sounds that are very similar to real guns, right? Prosecution is very mad about that. However, if he took the 180 days, his career would effectively be over. And he probably end up like maybe not getting divorced because I don't know if they're married, but it would probably cause a lot of relationship problems. It was 180 days in jail. Then they wanted 3-year probations. Then they wanted a delayed jail sentence of basically 7 to 8 years. Then they wanted a year of anger management. Then they wanted about 500 hours in community service. That means that for the whole 7 or 8 years, ASAP Rocky could not travel overseas. He could not do tours. On top of that, he would be on parole. So he would even need to ask his probation officer's permission to even go. I don't know about the city, but definitely go out of the state. On top of that, a lot of his contracts that he has with Gucci, Bottega Veneta, all these things, they have morality clauses. He could actually lose those contracts, be kicked off of them at board if he is a convicted felon. You know what I'm saying? So there's a lot on the line. It's a big gamble, but as this case unfolds, you will see that the court case is not that strong. But let's continue into ASAP Rocky's lawyer fighting for his life to get bullet casings excluded, and of course ASAP disassociating like a mug.
Set in a courtroom. In my whole career, both as a prosecutor and a defense attorney, I gotta be honest with you, this is not right, it's not fair to him.
You respond, Your Honor.
Hold on. Mr. Siegel, do you want to?
Yeah, the only thing I wanted to say.
I don't want you to repeat what Mr. Tacopina said. If you want to ask
I'm
something new?
tired.
No, but yes,
You're welcome to.
Like, are you adding new
Go ahead,
or like
dovetail what he
what's
said
yours?
with respect
You don't have
to
a proper
two arguments. And that is, the report says that the characteristics included are not limited to certain firearms. That means the universe of firearms in this case, based on the face of that report,
True.
is extensively broad. So given that, Your Honor, I think even just the probative value of this is substantially outweighed by the danger of undue prejudice, separate and apart from the late disclosure. So it should be excluded on 352. But that's secondary to the fact that it's just incredibly late at this stage for all the reasons Mr. said. So I'm just adding that additional factor.
Okay, now this guy, Mr. Siegel, actually came in and actually made some really good points. Partly because he was like, there's always two counsels on a law legal. One legal is like a legal eagle, and he knows what he's doing. They both do, but one is supposed to keep talking, the other one is thinking. They tag team. When the other one's talking, the other one is assimilating information and actually thinking. Siegel brought up some good points. One, prohibited value. What does that mean? It means that evidence, when it is kind of like, it needs to actually show that it will be in a bigger interest of justice than actually excluding it. They want to make sure that there's not a miscarriage of justice. This guy plainly says two things, which I think their experts will fight very hard in court once they get their experts. One, you're saying that this is from uh bang bangs like this, not the actual bang bang. So it's like saying like, yeah, it's in a under the umbrella. It could be this type of hammer, or it could be several other types of hammers. You don't know. It is all very general. Also, he's saying that you are not allowed to just drop evidence as a surprise thing. You're not allowed to just drop evidence. I know we see it all the time on TV. Yana, I have more evidence, but you're not allowed to just drop evidence in the 11th hour. He makes some very, very good case points. And I will also say this, even though whatever the judge's ruling is, if it does not serve ASAP Rocky well, this is the first ground, I believe, if they needed to go for a mistrial. And a mistrial, you need to prove that there was some procedural, or even an appeal, that there was some procedural policy that wasn't followed or wasn't adhered to. And because it wasn't, it ruined the whole case and you want to do it over again. They could argue that if this evidence is admitted, it was crucial evidence. And had that evidence been excluded, it's two things. One, it shouldn't have been admitted. And two, had it been excluded, ASAP might have won his case. It's a very good argument they're making, and they are setting the grounds just in case they need to do a mistrial or an appeal.
All right, what I'm hearing from you then, it seems like you're talking out of both sides of your mouth with the defenses. Like it's irrelevant. However, it's so prejudicial that it shouldn't be allowed in. It's so inculpatory that it shouldn't be allowed in.
No, I don't think anyone said it's so
God,
inculpatory. You don't understand.
He is
Saying
long-winded.
it's inculpatory is not accurate. No, I didn't say it's inculpatory, he didn't say it. What he said was there's a balancing test, because it says including but not limited to. All that simply means is, not that it's not inculpatory, not that, we just don't understand what this means. Not limited to means there's a universe of guns that have to be tested now. I don't know what not limited to means. So how many pistols does not limited to include? How many firearms does not limited to include? That's what it means.
That's a good point.
Okay, who wants to speak to the people? Go ahead, Mr. Rowe.
I want to take things one step at a time. Council brought up and made a comparison to what has happened thus far.
Just a minute. Alex, could you please go out and tell the jurors that we're dealing with some logistical matters, and just to please be patient, and we're going to come as soon as possible.
Yes, sir.
Go ahead.
One, as the court is aware, there is no logical reason why either Robert Hamadai's division or the DA's office would have in any way not turned this over. It's very clear that this evidence only helps our case. Although again, as the court pointed out, on the one hand, Mr. Tacopina says, the client cannot get a fair trial. This is so apparently damaging. Yet on the other hand, he says, hey, it doesn't really matter because it includes so many other guns that it should be kept out as being irrelevant. But what's very clear is, and I didn't appreciate the comment, when Mr. Tacopina suggests
He didn't appreciate
that
the comment.
he can't believe that the DA's office did not know about this in advance, when I spoke with him on the phone last night, that is not what I heard. What I heard was, say, listen, this is a problem for us. We understand, I'm going to quote
That's what you heard.
Mr. Siegel, yeah, there's no reason why you would have not turned this over if you hadn't, which is correct, and the record would support it. Comparing this, counsel is now discussing and saying how they are being victimized by
They
late
are.
discovery. The only late discovery in this case, and the court's aware of it, the court ordered that the discovery be turned over on 2 witnesses. It should have been turned over before the court ordered it.
With that, I don't want to deal with something that we've already dealt
Okay.
with. Oh, I understand about the 2
Move
defense
on.
witnesses. We've covered that. Just
Wrap it
deal
up.
with the present issue.
So, what counsel did is, he cited last night, he sent to the court a case called Hughes, 2020 case, 50 cal at 5th at 257. He included no facts about that case. At 2 in the morning, I went and I read the case, and I then sent an email. That case, so the record is clear, involved a situation where there was a Watson murder and where the defendant was being tried on a theory that his alcohol intoxication had caused the accident. The investigation had been done by the MATE team, and they had determined that in fact it was speed and not alcohol. This was a very huge problem
Okay,
for the
let's
prosecution because that was the theory of their
pause,
case.
right?
Apparently, the head of the MATE team started redoing a separate investigation, which the evidence suggests the prosecutor was well aware of. At the very least, and as the Court of Appeals said, the prosecutor was given information that in fact the MATE lead detective now had a new opinion contradicting the prior opinion that in fact, in actuality, it was caused by alcohol and not by speed. Instead of turning this over to the defense, the prosecutor literally had the witness on the stand in front of the jury. He then pauses, looks over at the defense and says, hey, by the way, here's the diagrams and here's the information that he's going to be testifying to. Defense is obviously horrified because it's the entire case. The defense asked for a mistrial. They asked for a continuance. They were both overruled. The Court of Appeals said, hey, listen, obviously the suppression of evidence, as the court is aware and under the statute, is the last option a court can utilize, only after every other option has been determined to be not harsh enough or not accurate enough in addressing and solving the situation. Court of Appeals said, hey, listen, Judge, you had a chance to do less remedy. You didn't do it. The jury ended up convicting, and the case was reversed. To compare that case to the facts of this case, it is distinguishable for the following. Number one, that evidence was not just inculpatory, it was the entire case. Number two,
now,
the prosecutor,
here's
for
the
a
thing.
tactical advantage, which the court
Here's the thing. The prosecutor, and again, I think they're arguing so much for this evidence to get admitted, they haven't, or maybe they have thought about what they're actually doing. Remember what I just said, that ASAP's people have effectively laid the groundwork, that this evidence is so pivotal to the case that because they gave it to them at 6 a.m. this morning and they don't even know what they're looking at, they haven't even found time to wrap their minds around it. It was a sneak attack. It should be excluded. Now, the prosecution, because they are fighting like dogs to get it in, are saying, hold on a second, hold on. And they're citing case law talking about there was ever evidence that was so pivotal for the case that if we didn't let it in, the whole case would have fallen apart. So they're also arguing that this firearm ballistic thing is pivotal to everything. They're arguing that it is pivotal to everything. Now, I do want to say this with them arguing that it's pivotal to everything. Okay, boomer, you're going to pay for this when ASAP, if he loses, and I don't think he will because we'll talk about it, but I think this is very thin evidence. When ASAP, if he does lose, the prosecution, by their own testimony in court, has said that this was pivotal evidence. So all they have to prove is this evidence was improperly included and should have been excluded. So again, that was a bad move.
of Appeal basically said in a footnote that although the original trial judge had found no prosecutorial misconduct, that in essence the record didn't support it, meaning that there was misconduct that the prosecutor knew. The prosecutor decided, for a tactical advantage, that he was not going to turn it over. He then did it while the witness was on the stand. He then opposed any continuance or mistrial. Here's what we have. We have evidence, which it is inculpatory. It's inculpatory because the defendant is found at his location, at his house. There is a 9mm magazine for a Glock 43, and there's no Glock 43 to go with it. So it's just a magazine. we already knew that the defendant had the Glock 43 magazine, and we knew that these were 9mm casings. The difference now is that there's going to be evidence that suggests that a Glock 43 is more likely to have put the marks on the expended casings than many other firearms. So the idea that this would be excluded under 352 is patently absurd. The idea
Why?
that Hughes is in any way authority for what they're asking is also absurd. We talked to the lab this morning. First, what we are proposing is that we will not mention this evidence in this case in opening. We will wait and see how the case develops. As the court is aware, and the court is aware of this from the discovery of the witnesses that we got the day before we started trial. The defense is now claiming not only that it was a starter pistol, but they are claiming that the 9mm magazine, which was found at the defendant's residence, actually belonged to the defendant's manager, and that he is going to testify. So let's look at how this plays out. If the defense ends up being that in fact this 9mm magazine belongs to
Counselor.
the manager, that in fact what was used at the scene was a starter pistol / prop gun, then although we don't believe that's credible evidence, that is where they're going. So here's what we're asking. One, there's no late discovery instruction, because as the court is aware, and maybe counsel is not, to have a late discovery instruction, the court has to find that we had the information and didn't turn it over. There's no reason why we wouldn't have turned it over, and as soon as we had it, we turned it over. And as the court's aware, I've been trying cases in front of His Honor for going on 30 years. As soon as we found this evidence, we contacted the court and we contacted counsel. Number two, the lab has told us that basically what they did in this case, to have someone else examine it is a very quick examination, and the amount of time that it should take for someone to examine it and end up being able to assess whether or not LAPD was accurate in what they found is ranging from
This
a
ain't
few
making
hours
sense.
to maybe a day. This is what we would propose. We would propose that at this
What do
point
you
in time, we will not mention this in opening statement. We will see how the case develops. We
Okay.
will, if we believe that this is evidence that is going to be important, we will ask to admit that evidence later on in the trial. In the meantime,
This makes no sense.
we will make arrangements for counsel, and they can hire any qualified firearms expert. I want to distinguish between Hughes and this case. Hughes was an extremely complicated accident reconstruction involving a vehicle where multiple individuals died. It was very time consuming. It's an extremely complex investigation. This is very minor and simple ballistics interpretation. So we will make it available. We already have sent our investigators to recover the evidence. I don't know if they already have it.
I believe they've already.
We believe they already have the evidence, they have it with them, and we will get it to the defense. And I just, this is related to the other issue, so I just want to make sure that this is clear. Counsel seems to be under the impression that the court has now changed its ruling, and that we are not allowed in our opening statement to address the idea, which the court previously ruled we could, that we did not find out about this defense until the 20th. The court had said previously, on the record, yes, Mr. Lewin, you guys can address that issue in opening. I will decide whether I'm going to issue a discovery instruction later. Council believes you've now said we can't do that.
I did say that.
Yesterday, yeah, pretty
Yeah.
clearly.
I had said yesterday that the purpose for an opening statement is to give the jury an idea of what the evidence, what you believe the evidence will show. Talking about late discovery, that's argument. So as far as your opening statement, I don't want you to mention anything about, you just found out about a starter pistol. That is not part of what the evidence will disclose. I talked about that yesterday.
So but I am correct, the court's original ruling was.
Yeah, that is what I said. Originally, I said, yes, you can bring it up.
Okay.
But then after thinking about it, that's not part of an opening statement, so I don't want you touching it.
Okay, understood.
Go on with the present issue about the ballistic.
So where we sit right now is that counsel is arguing two inconsistent positions. They're arguing that this evidence is so damaging that we have to start over. Now, that's not a vacuum. It's very clear that the defense is not happy with this jury. They've made it clear.
Hold on.
No, don't interrupt.
Okay.
He didn't interrupt you, don't interrupt him.
It is very clear by the
The
comments
judge
the
is
defense has
stressed.
made
They are
in
getting on their
court,
last nerve.
where they have repeatedly said that their client is not getting a fair trial because of what they believe is the composition of the jury, the fact that they have filed a writ, the fact that they have continued to bring this up, leads to the inescapable conclusion that what they are looking for is a way to start over. I believe, Your Honor, that what we have proposed is more than fair, because in the end, Your Honor, they're arguing it both ways. As the court mentioned before, I ever pointed out, they're arguing, if you let this in, Judge, my client can't get a fair trial. Oh, by the way, what's the value of this anyway? What does it matter? Again, my position would be the second argument is inaccurate. It is evidence that is helpful to our case. It doesn't prove the case by itself, but it is definitely helpful. It is not irrelevant. It's not 352.
All right, you don't have to go on.
Okay.
I believe I have enough information to make a
Okay.
decision.
All right, you've heard, please.
No, you can't.
I can respond to what he just said about the
He's like,
jury.
no, you can't.
It doesn't matter about what he said about the jury. That has
No, it
no,
doesn't.
stop. That has no bearing on any decision I'm gonna make.
There's a record, though. There was a record.
I don't believe that you are unhappy with the jury.
I'm
Mr.
not.
Lewin might say you're unhappy with the jury, but that's not, I don't believe
Okay.
you are. If you were, you wouldn't have
People,
accepted the
really
jury.
quick, ASAP's people need to very, very quickly back off of this. It is never a good idea to piss the judge off. And the judge is getting very, very upset. He's sick of everybody talking. He's sick of blah, blah, blah. He's like literally, and he doesn't like the way ASAP's lead counsel keeps interrupting, obviously. But more important, it is, even though you guys are like, yo, chill, like you're getting the judge angry. It is important that you go on record, not just to argue back and forth, but you have to go on record and put it on record. Your Honor, there's certain language you use and the lawyer knows it that will come up if they need to preserve this for there's either a mistrial or the appeal. He hasn't said the magic words yet, but he is arguing a lot. I think he's trying to see how much he can push the judge. Hold on.
I believe that both sides are satisfied with this jury and that both sides will get a fair trial. You don't need to respond to it because it doesn't matter whether he does or does not think you're happy with the jury. I believe that you are satisfied with the jury. All right, here's the way I want to deal with the latest, recently finding out about this ballistic report. Everybody at the table, all counsel, to me, has great credibility. I accept what all of you say. I don't believe that there's been any nefarious conduct by anybody.
Oh, wow.
If this late report involved, all of a sudden, it was disclosed that a witness, an additional witness positively identified Mr. Mayers as the shooter, that would be very critical and crucial. If a witness came forward and said, yeah, Mr. Mayers confessed to me that he shot ASAP relative, that would be very critical and crucial. if a firearm, if a 9mm was recovered, that could be ballistically compared to the casings, and that just became discoverable or became disclosed, I think that would be critical. But that is not what happened here. What I'm seeing here is that the casings that were recovered were examined, and the opinion is they could have been fired from a Glock 43 or any other number of types of 9mm. You have said that, well, now you want to hire a ballistic expert. That's not fair to you and your client. So this is what I am proposing. We have a list, a Superior Court list of firearm examiners that have been recognized as experts. My star judicial assistant over there, Alice, will print out that list. Ms. Kaplan is an attorney who practices in this area. If there is someone on the list that you want to hire, contact that person and tell them this is crucial that the ballistic evidence be examined now, not later, but now.
Okay.
The court will pay for it. Mr. Mayers will not have to pay for this. We will. If the firearms examiner wants extra money because it's a rush, the court will pay for it. If you are not satisfied with the people on the list, then if you want to find your own examiner who will do the examination, the court will pay for it. If it's necessary that I speak to the examiner to
Okay.
impress upon the examiner the importance of getting this done ASAP, I'm glad to do that.
So again, this to me is laying grounds for a possible mistrial. You cannot say that it's not just enough you pay for a court reporter. It's also to the point that the defense has time to analyze the information and find the appropriate things. To say that you'll pay for someone last minute, you don't understand how these experts work. They are locked in months in advance, especially the best of the best. If you have someone that you feel can do it, you call them. It's like getting in for like somebody being like, yo, I'll pay for the best lawyer available. Don't worry, we'll pay for it. And you're like, okay, but Johnny Cochran's not available. Mark Garagos isn't available. You know, Siegel is not available. Just because you're paying for it does not mean that we will be able to find the best expert. And we're not going to rely on the prosecution's expert, because the reason the prosecution is using them is because they like what that expert is talking about. I don't think this is actually a good move, but let's continue, okay?
I'm providing my cell phone number to all of you. If you need to call me any time of the day or night, I will speak to you. I will speak to a firearms examiner. If you feel it is necessary, Mr. Tacopina, we can be dark on Monday.
Okay, so
But
they're
I'm
saying
not
they're giving them
excluding the evidence. I don't find that there is any nefarious conduct.
Oh, wow.
The evidence is relevant. It's not a smoking gun, but it is somewhat inculpatory. But in and of itself does not mean that your client is guilty. That's the way we're going to deal with this, and that's the final ruling. I don't want to hear anything more about it.
Okay, so first of all, the judge, they talk this man so much he has an attitude, but this is actually really huge, and it's not the best thing for ASAP Rocky. They have a gun. They're going to show ballistics saying most likely it came from this gun. Now they just opened up a whole avenue that after ASAP rejected the plea deal, he's going to have to argue, well, okay, fine, but that's not my gun. This is a whole new arm of arguing that they're going to have to get evidence and argue. And they didn't know it was till the 11th hour. If this was a criminal case that went on 3, 4, 5 months, maybe you could argue. But for a case that's expected to last at least 1, at most 3 weeks, this is a lot to get on top of. On top of guaranteeing that the best people, and by best people, I mean on top of guaranteeing that the best experts, because there is quality of ballistic experts, will be available to review, to look at the evidence. And also, they're forcing the ballistic expert to go off of their findings. They don't have time for an independent ballistic expert to actually inspect the casings and even make sure what the first ballistic expert is saying is true. Now, why is that so important? Because I believe it was in Boston and a few other places, there were scandals where people, when they sent items to the lab to be inspected, whether it was a narcotics bust, whether it was bullet casings, every time they say this is what you sold or this is what they do, they actually need to independently verify. There were cases where people were arrested for selling Coca-Cola, if you will, out of little white baggies. They would send them to the lab. The lab would be like, oh, yeah, it's grade A. You better send them to jail. Prosecution came back and they said, guess what? We had it tested and it is, in fact, Coca-Cola. Because if it was baking soda, selling baking soda is not illegal. At most, you can sue me for fraud because I sued you baking soda and you thought it was like, Colombian dancing desk. But even with that, you cannot sue somebody if you were planning on doing something illegal. Anyway, it came out in the testing that the lab people that worked for the police and the prosecution were actually falsifying information, falsifying information, falsifying test results because they were just going along with what the prosecutor said. So if you guys think that, oh, well, you'll just have any independent expert look at it, no, you want your own people in there to actually verify what in fact is going on. Y'all feel me on what I'm saying, right? I don't think he should have taken a plea deal. I will say I think he's going to beat this. Again, I've been talking to legal experts. I think he's going to beat this. But even with the plea deal was basically making yourself sticky. They would have gotten you one way or another. It was making yourself sticky. You know what I'm saying? In any case, let's get back into this. The judge actually really did do ASAP a disservice, but let's get back into this, shall we?
That's the end of the issue for now.
Okay.
Are both sides ready for the jury to come in? Do not mention anything about the ballistic comparison in the opening statement.
That was our question.
So,
Yeah, do not mention that.
Understood.
Your Honor, what I was planning on mentioning
my
was
God.
that the cartridges found at scene were 9mm. In the defendant's house was a magazine that was 9mm.
All right.
And had some 9mm live ammunition in it. That was it.
If that has been part of the discovery and that was known, then that's fair game.
Yes.
But this ballistic comparison, that's off limits
Correct.
for the opening statement.
Okay.
Understood.
All right, bring the jury.
All right, so the jury is about to come in,
Oh,
but
yeah, do you want that to Ms. Kaplan?
really quick, you guys, the jury is about to come in. They're going to be seated. Opening arguments are going to happen. But if I'm not mistaken, they're on recess right now. I believe they're going to come back off of recess in about 13 minutes. Let's get into this. Let's see what the jury looks like, the peers that are going to judge Rocky. And then we're going to take a recess and then reconvene when
The list of the firearms examiners.
I could also email it down to the press.
Just print it. Yes, sir. If you,
okay, hold on. What happened? Where are you? Hold on. They're still on jury break, I believe. Let's get this jury in here, shall we?
Get it to the defense.
Please, on-
no, you can't.
I can respond.
You. Mention anything about
Okay, hold on.
the opening statement is what the attorney believed the evidence will show. Whether the evidence in fact
Okay, so they didn't show the jury, I guess out of respect for the jury, but let's keep going.
shows what they believe, well, we'll all know that at the end of the case. Once the opening statements are over and we begin with the testimony, if you are a note taker, that would be the time to start taking notes. Mr. Prislovic, the floor is yours.
Thank you, Your Honor. Good morning, ladies and gentlemen. I wanted to start off on behalf of myself, Mr. Lewin, I'm sure on behalf of the defense too, and all the court staff, we all want to thank you so far for the time, attention, and candor that you gave to us during jury selection. We all understand that was a long process, and we appreciate your attention.
Wrap it up. We don't
After going through that long process,
Okay.
I'm sure some of you are thinking, wow, this must be a difficult case, or this must be a really complicated case. And to be fair to you, if I was sitting in your position and I looked out on the number of jurors that we started with, or even the number of attorneys that are up here, I probably have the same thought myself. But what the evidence will show in this case, and what will become almost instantly clear, is that this is not a complicated case. The evidence will show that the events in this case were captured on surveillance video. I'm going to start this whole presentation out by playing the video for you. So you will have that frame of reference as we're talking about different features, the people that were involved, the locations that are involved, and what happened. You will already have seen the video. The first video that I'm going to show you was captured on November 6th of 2021 at around 10:10 p.m. just outside of a parking garage entrance, mid-block, so on Argyle, in the middle of Argyle, between Hollywood Boulevard and Selma. The second video that I'm going to show you was captured 7 minutes later, so at 10:17.
Okay.
It was, if we're being generous, 2 blocks, maybe 1 city block away from the first location,
Okay.
down Argyle, around Selma, at a small intersection called Selma and Vista Del Mar. So I'm going to play the first video for you, that outside of the parking lot.
All right, let's see this first video. I've been curious to see it. Hold on. Because what?
Now I'm going to move to the second location, that at Vista Del Mar and Selma.
Okay.
And I'm going to pre-warn you, it's a little small, it's at a distance, so you're going to want to focus your attention at the top left-hand corner.
Okay. Now, let me stop by saying this really quick. This is really bold for them to be cutting up in the middle of the daytime. Just cutting up.
All right.
Like,
Now let's
damn.
go over the details. As I said, the people that are involved, the location, and I'll give you an explanation of what you've seen on these 2 videos. This case takes place in the heart of Hollywood.
I do not believe he's guilty.
This is the iconic Hollywood and Vine. The picture you see here is just a demonstrative picture of that intersection, but it's an iconic intersection in Hollywood. That intersection is about 1 block 1 block west and 1 block north of the crime scene. So for those of you who are familiar with Hollywood and that intersection, it's a pretty big landmark, and that's where I want to focus your attention. Now, the actual shooting in this case takes place on a much smaller street, Selma and Vista Del Mar. But this is the area around where that shooting took place. It is a very densely populated part of Hollywood, and there are some landmarks on there that you might be familiar with, just so that you can familiarize yourself with the location that we're talking about. The Capitol Records building at the top, the W Hotel, and Hollywood Boulevard.
Okay, get to the point.
The shooting, as you've seen, occurred just outside of a parking lot on that corner of Vista, Del Mar, and Selma. That was a parking lot at the time that was full of cars, and it was ringed by a nightclub on the corner, a sound studio, a hotel, and 3 different apartment buildings right around. As I said, densely populated. This was also Saturday night. Saturday, November 6, 2021, at about 10 p.m. in Hollywood.
Okay, so
This is a time that Hollywood is busy. Now that you understand kind of the locations that are involved, I want to
Hi,
I want to start with how this case starts for LAPD.
I live in the apartment on the corner of Argyle and Selma in Hollywood, and there's just been a shooting.
So at 10:18 p.m., LAPD receives this call that there's been a shooting at the intersection of Argyle and Selma. The call continues though.
Did you see anything or you just heard it?
Yes. No, we watched it.
Okay, what did you see?
There were 4 men, and they were kind of fighting as they were walking on Argyle, and then they turned left onto Selma. We heard yelling and they started running, and they turned left into the back lot apartments, or El Centro apartments.
Now the 4 men that you see on that screen will be the 4 men that we'll talk about in a minute. They were the 4 that were at that location.
And then someone pulled out, the guy in the black sweatshirt pulled out a gun.
Okay.
And he shot, and I think the guy who shot was blue.
Now the evidence in this case
so for everybody's
will be
thinking
that
thought
the
they were
man in
showing
the black
video,
sweatshirt was the defendant, Raheem Myers.
they're showing video to their advantage. They show the whole uncut video, it looks a little. So they're trying to show the part where they're like, look, this ninja did it. He's right there. That's what's going on with the video that he's actually showing. Hold on, let's keep going.
That evidence will be uncontradicted. As you have heard throughout jury selection, Mr. Myers is an entertainer and he goes by the stage name A$AP Rocky. You will hear other nicknames that he is referred to in the evidence in this case, including Flacco and Luigi. At the time of this crime,
Hey, my man, Luigi.
Mr. Myers was 33 years old. He has his own company that I believe is referred to as AWGE, A-W-G-E,
Okay.
that will also, you will hear referred to in the testimony in this case. And as we've talked about, his significant other is Rihanna. The victim in this case is a man by the name of Terrell Efron. And Mr. Efron, you will hear, was also a member of the A$AP Collective, and he went by the nickname A$AP Relly.
Okay.
Mr. Efron was also 33 years old at the time of this crime. And what you will hear from Mr. Efron is that he was friends with Mr. Myers well before this case and well before even Mr. Myers was a famous individual. That essentially, I believe they met in high school and grew up together.
Okay.
He has known Mr. Myers 18 or 19 years at the time that this shooting happens. And you will also hear that he, too, at the time was working in the
Pause. Why they got like a picture of A$AP looking like a criminal, and this is the picture they showed of A$AP Relly, and they're really trying to make him look like humble, innocent, and this is the most innocent they could make this fool look. Look at his facial expression. I don't even know what you did, but I don't trust you. He got a sneak. You ever heard something where somebody's like, "Yo, you got a sneaky face"? He got a sneaky face. If you walked into a room and saw this man looking at you, right? You walk in the room and saw this man looking, it don't matter what happened. Cookies are missing, something's wrong with your purse, a window's broken, somebody didn't pay the light bill, whatever it is, if you walked into the room and we were all around and you saw this man's face, I don't know, this is the most innocent you can make this man look. Maybe he's guilty already. Anyway, let's keep going. Let's keep going.
The music industry, and he had his own company called Shut Eye Entertainment. Now, I mentioned it already, but to put a finer point on it, the group that both of these men were members of is called A$AP. It doesn't stand for what you probably thought it did when you walked into court. It's an acronym for Always Strive and Prosper. Was formed by high school.
Is it really mean always strive or prosper? Or did he try to hit them with a young thug defense? Your Honor, it doesn't mean thug. It means truly humble under God. Y'all remember with the young thug trial, truly humble under God, always. Is that what ASAP actually means? I don't know. I don't know. Let's keep going.
School-age kids in Harlem, New York around 2006. They call themselves a collective. You will hear are rappers, producers, music video directors, designers, people that have different artistic pursuits that essentially work together. And there are many members of ASAP. The ones that you will primarily hear in this case are obviously Mr. Mayers, the victim, but also the two friends that were with Mr. Mayers at the time this happened. And they go by ASAP Ills and ASAP 12E. And I will just pre-warn you that 12E gets spelled a bunch of different ways. It's not always consistent. And there will be one last member that you'll hear about briefly who goes by the stage name ASAP Bari. Sometimes people refer to him as Young Lord.
Okay.
As I said, the four main members of this group that you will hear about are these four men. The victim is on the far right, Mr. Efron. The defendant is the next person to his left. As I said, ASAP 12E, his given name is Jamel Phillips, and the last is Elijah Ulanger, who goes by ASAP Ills.
Got it.
And these were the four men who were present at the time of both of these incidents. Now I want to take you to that weekend, Saturday night in Hollywood. There was actually at the time a music festival or concert series going on known as Complex Con in Long Beach. And you will hear that Mr. Mayers was to be a performer at that event the day after the shooting, the Sunday, November 7th.
Uh-huh.
Now, although I told you that Mr. Mayers and Mr. Efron were close at one point, you will hear that throughout their relationship there was tension between the two of them. And that tension was essentially building up to the night of November 6th, 2021. You will not hear all the reasons why there was tension between the two of them, but we will get to the point the day before this shooting, November 5th, 2021, when that tension kind of comes to a head. But what happens on that day, Mr. Efron will tell you, is that he is in a car with that last member of the ASAP group that I talked about, ASAP Bari. The two of them are driving when ASAP Bari receives a phone call from Mr. Mayers. And ASAP Bari takes that call on speakerphone. So Mr. Efron, who's in the car, can hear both sides of the conversation. He can hear Mr. Mayers and he can also hear ASAP Bari. And in the course of that call, Mr. Efron, the victim, heard the defendant saying these rude and aggressive things about him. Mr. Mayers at the time does not know that Mr. Efron is in the car with the victim.
Okay.
This leads to the next day, November 6th, 2021. You'll hear that Mr. Efron was in Los Angeles working with one of the artists that he managed.
ASAP is
He
disassociated
was
like a
asleep
mug. Look at that.
around
He is
9 o'clock
literally
p.m.
in his head. He ain't come
when
back
he started
yet.
receiving a series
I would be so worried.
of urgent
For 24
messages
years?
from not only from Mr. Mayers, but from the two other men that were with him, ASAP
Okay.
Ills and ASAP 12. And you'll hear that he received a number of calls kind of back to back to back from the three of them. Now, he didn't answer those calls because he was sleeping, but when he ultimately woke up, he saw that he had a number of missed calls. He also received text messages from Mr. Mayers that were aggressive, seeking a confrontation with him, asking him where he was, Mr. Mayers is on the left side of this conversation. Where are you at? Let's get to it. Stop ducking my calls. The messages that the victim's receiving are instantly aggressive towards him.
I mean,
So you will hear from Mr. Efron that he called the defendant. He was groggy because he had just woken up. They had a conversation and they agreed to meet outside of the W Hotel in Hollywood. Mr. Efron will tell you that as he went to that meeting, he was of the frame of mind
where you at? Let's get
that
to
he and
it.
Mr.
Stop
Mayers
ducking my
were going
call.
to have a confrontation. That he believed they would argue, and that ultimately this would lead to kind of repairing their relationship. So they would each be able to speak their piece and essentially fight like brothers do, and then it would ultimately bring them closer together. They would
Is that what we
repair
thought?
sort of the issues that they each had with each other.
Okay.
So that's how Mr. Efron is going into this meeting.
Uh-huh.
Now, let's talk about the location where they meet, this location just outside of the W Hotel. You're going to see this map throughout this case. So I want to take some time to walk through it with you so you understand the various features that are depicted here. On the left side of the screen is Argyle Avenue. On the bottom of the screen is Selma Avenue. And on the right side of the screen is El Centro Avenue. Now you can't see it in this map, but if the map were to continue off the top of the screen, Hollywood Boulevard would be just above that. In the middle of this map, there's a small street called Vista Del Mar that kind of goes north and then forces you to go east.
Okay.
The red arrows that you see here are the path of travel that Mr. Mayers took that evening. So it starts at that mid-block location on Argyle, continues down to Selma, and then up Vista Del Mar, around that corner, all the way to El Centro, and then he made a left turn on El Centro and went above, off the map. The numbers in the red boxes that you see here, 1, 2, 3, and 4, are the 4 different locations where the police were ultimately able to recover surveillance video from. There are 4 different locations. Attached to each one of those locations, you'll see the green triangle and with a green arrow in the middle. And what that represents is very roughly, this is not meant to be, exact, but very roughly the direction that a camera attached to that building was facing. You will also hear that locations 1, 2, and 4 captured video only. But you will hear that the location with the number 3 captured both video and audio.
But to be honest, the audio could have been the prop guy. I'm going with
So
the
I
prop
told you there's
guy.
2 incident locations, 2 altercations that happened. The first happens where the yellow box is right now, right outside of that parking garage. The second happens at that corner of Selma and Vista Del Mar. And that's where the firearm was actually discharged, where the gunshots were fired.
Okay.
So the first location I want to focus on is that where the initial confrontation happens. This location is the entrance and exit of a parking structure. This is that parking structure entrance. If you were standing
Hold on, guys. Hold on.